Hello and welcome to this Taylor Wessing webinar update on the subject of supplementary protection certificates. My name is Matthew Royle and I'm joined by two colleagues, Judith Krens from our Amsterdam office and Verena Bertram from our Munich office. In the next 45 minutes or so, we want to bring you up to date with what is happening in the SPC area since our last webinar over 12 months ago on the 12th of December 2017. In fact, there is quite a lot to cover because despite the relative brevity of the SPC regulation, or potentially because of its brevity, it continues to give rise to more CJU references than any other area related to pharmaceutical patenting. In fact, most of these references continue to concern two issues. Exactly what products can be protected by an SPC and how exactly they must be specified or identified in the underlying basic patent in force. This is where most of our focus will be in this update today, but there is also the hot topic of the manufacturing waiver for export that's currently progressing quite rapidly through the EU legislative process. But before we get started, let me say we would welcome any questions. You can send these using the Q&A icon in the middle of your screens. We will then get back to you by email as soon as possible after the webinar. Also, please hold on for a moment at the end of the webinar for a survey that will pop up on your screen as soon as we've finished speaking. We use the feedback that you give us to decide on future webinar topics and how to improve them, so any feedback that you can give will be much appreciated. Okay, let's start by reminding ourselves what the SPC regulation is for and what it says, and then go on to the subject of products. For this, I'm going to hand over to Judith Krens in our Amsterdam office. Judith.
Yes, thank you, Matt. In short, SPCs are designed to provide additional market exclusivity for an authorized medicinal product when significant time has been lost on the underlying patent term while marketing authorization is awaited. But as with patents, the SPC system also has to maintain a balance between encouraging research on the one hand and allowing third-party competition on the other. So, there are limitations on the circumstances in which SPC protection can be allowed. These are set out in a number of conditions in Article 3 of the SPC regulation, which are shown on the slide. In particular, note the ones in bold. Article 3A, the product is protected by a basic patent in force. And Article 3D, the marketing authorization is the first marketing authorization in place to put a product on the market as a medicine. And Article 1B, product means the active ingredient or combination of active ingredients of a medicinal product. The subject areas that Matt said we are focused on today relate principally to these. Specifically, the cases I'm discussing are concerned with mostly Articles 1B and 3D, and the question of what sort of product can be protected by an SPC. Verena is then going to talk about Article 3A concerning how we know if a product is or is not protected by a basic patent in force. So, let's start with the definition of product. The attempt to draw a line around what is an active ingredient and therefore a product for the purpose of the SPC regulation has proved difficult in recent years. It didn't start that way because at one time the CJEU authority on the meaning of active ingredient in Article 1B had appeared to take a clearly strict approach, as exemplified by the decision in Massachusetts Institute of Technology. In MIT, an SPC was not permitted for a combination of the cytotoxic agent carmustine and the polymeric matrix polifibrosan, in circumstances where there had been a marketing authorization for carmustine alone, before the marketing marketing authorization for the combination. This decision was because folaviprozan was not regarded as an active ingredient. It is a substance that doesn't have a therapeutic effect on the human or animal body of its own, but merely provides a pharmaceutical form for the active ingredient to work. So the combination was not a different product to carmustine alone. Furthermore, in Wessing research, the CGEU ruled that product in Article 1b must be interpreted strictly to mean the active ingredient and could not include the therapeutic use of an active ingredient protected by the basic patent. In summary, these two decisions were authority that a product is an active ingredient per se, not an excipient or other non-therapeutic substance, and not a second medical use. However, this approach then came into question in July 2012 with the CGEU ruling in Neurim Pharmaceuticals. This case actually addresses Article 3D of the SPC regulation rather than Article 1b. But because Article 3D also relies on the definition of product, the ruling in this case is difficult to reconcile with the strict approach under Article 1b. That ruling under Article 3D said that melatonin, specifically for the treatment of insomnia in humans, could be subject to an SPC on the basis of a marketing authorization granted for this purpose in 2007. This was despite the fact that melatonin, for a different purpose, regulating the seasonal breeding of sheep, had already been the subject of a marketing authorization granted in 2001. In other words, SPC protection for the different application of a previously authorized ingredient is permissible. In this ruling, the CGEU appeared to follow the earlier Advocate General's opinion, adopting a teleological approach to the meaning of product rather than a strict one. In essence, this means the court should look to the purpose of the SPC regulation, which is, very broadly, the policy I've already mentioned to provide sufficient protection for the investment made in the research and development of medicinal products. Not surprisingly, this decision has subsequently motivated SPC applications for a number of products that would probably not fall within the strict approach, but which are the subject of significant investment. Let's take a look at these now. What about adjuvants? Are these active ingredients? In GlaxoSmithKline Biologicals, SPC applications were made both on an adjuvant, called ASO3, combined with an antigen, an influenza virus component, and on the adjuvant alone. Specifically, the applicant argued that an active ingredient includes the ASO3 adjuvant in its own right. Upon referral, the CGEU decided that an adjuvant to a vaccine having no therapeutic effect of its own was not an active ingredient capable of protection by an SPC, either alone or as a combination of active ingredients with a vaccine. The decision in GSK Biologicals therefore appeared to limit the application of the teleological approach to ingredients capable of their own therapeutic effect, as previously thought. But then, a very similar issue was tested in Bayer Crop Science. The CGEU ruling in Bayer Crop Science concerned what is called a safener, that is, a substance or preparation which is added to a plant protection product to eliminate or reduce phytotoxic effects of the product on certain plants. But safeners are not themselves active pesticides, and on the facts of the case, the referring court held that safeners could at most only be said to have an indirect effect on plants. Could these be the subject of an SPC, under the equivalent SPC regulation for plant protection products. In this case, the CGEU ruled that product and active substance may include a substance intended to be used as a safener, where that substance has a toxic, phytotoxic or plant protection action of its own. But, the ruling suggests, this action does not need to be limited to action directly on harmful organisms as a protective substance, but may also include its protective action indirectly. If one compares the action of a safener with the adjuvant in GlaxoSmithKline, which could also be said to have an indirect effect, the cases appear inconsistent. Then there was another referral to the CGEU in Arne Forstgren. This concerned an SPC application for a conjugated carrier protein, protein D. Protein D is present in a pneumococcal vaccine for pediatric use called Synflorix. Synflorix is the subject of a marketing authorization which the SPC applicant relied on. In Synflorix, protein D is conjugated by covalent bonds to several pneumococcal polysaccharide serotypes and absorbed on aluminium phosphate. While protein D does not contribute to the activity of Synflorix, the applicants argued that it does have active properties of its own, albeit that these are against a different bacterium, Haemophilus influenzae, and so not covered by the Synflorix marketing authorization. The CGEU didn't permit the SPC in this case because such active effects as protein D had did not fall within the therapeutic indications covered by the marketing authorization. But, relying on the ruling in Biocrop Science, the applicant also argued that protein D contributes to the induction of a specific immune response to the pneumococcal polysaccharides, to which it is conjugated. However, the CGEU was unwilling to make a comparison with Biocrop Science and left it for the National Court to determine whether these claimed effects amounted to a pharmacological, immunological or metabolic action of their own. There's one more referral to the CGEU on this subject area, which has just recently received an opinion from the Advocate General. This is Abraxis Bioscience, which again addresses products as well as the issue of whether there is consistency between the rulings on Article 1b and 3d. Abraxis markets nab-paclitaxel as Abraxane. This comprises paclitaxel formulated as albumin-bound nanoparticles. According to Abraxis, nab-paclitaxel rather than paclitaxel is the active ingredient of Abraxane, due to the tight association of paclitaxel to albumin. The UK Intellectual Property Office refused Abraxis' application for an SPC, saying that, under Article 1b, the role of albumin did not change the fact that paclitaxel is the active ingredient of nab-paclitaxel, and that paclitaxel is the subject of an earlier marketing authorization. Abraxis argued, however, that in light of Neurim, Article 3d of the SPC regulation was capable of protecting a new formulation of an old ingredient. Arnold J. in the Patent Court observed that the CGEU's reasoning in Neurim doesn't make clear how its approach to the meaning of a product under Article 3d can be reconciled with the strict interpretation of a product under Article 1b. So, the judge asked the CGEU, in essence, if Article 3d permits the grant of an SPC for a new formulation of an old and previously authorized active ingredient. The AG's opinion of the 13th of December 2018 essentially restates that Article 3D of the SPC regulation precludes the grant of an SPC where the marketing authorization relied upon in support of the application for the SPC is not the first marketing authorization for the active ingredient or combination of active ingredients. This should, he says, apply in a case such as this one, where the marketing authorization relied upon for the SPC is the first to cover a formulation protected by the basic patent. The CJEU ruling in this case is awaited. If it follows the AG opinion, this would be consistent with the strict interpretation of Article 1b from the earlier MIT case, and would appear to limit the application of Neurim, at least as far as formulations are concerned. In another recent development in this area, Santen versus Director of the French Patent Office, dated 9 October 2018, the Court of Appeal of Paris has made a reference to the CJEU, seeking to clarify what the court meant by a different application of the same product in the Neurim case. The active ingredient of Santen's Ikervis product is cyclosporin, indicated for treatment of severe keratitis in adult patients with dry eye disease. Santen sought an SPC for cyclosporin eye drop emulsion for the treatment of keratitis based on its patent ophthalmic oil in water type emulsion with stable positive zeta potential, and a central marketing authorization for Ikervis. Cyclosporin had not previously been authorized for the keratitis indication, but it had been the subject of an earlier marketing authorization in the form of the product Sendemum. Sendemum indications include the treatment of an eye inflammation condition called endogenous uveitis. The SPC application was rejected by the INPI under Article 3D of the SPC regulation because of the earlier cyclosporin marketing authorization. The INPI held that the Neurim decision, which allows subsequent SPCs for different applications of the same product, if the application is within the limits of the protection conferred by the basic patents relied upon, did not apply. Its reasoning is that the indications in both Ikervis and Sendemum both relate to inflammatory disease of the eye. In other words, it thinks these are not different applications. The INPI also held that the basic patent needed to be limited to the new application of cyclosporin to keratitis, rather than a new formulation which had numerous applications including keratitis. On appeal of the Director's decision, the Paris Court of Appeal has referred two questions to the CJEU in order to clarify what amounts to a different application of an active ingredient, and whether the basic patent in force must be limited in scope to that particular application. It will be interesting to see what the CJEU decides about this case, and indeed Abraxas. But note that nearly 7 years after it was decided, the CJEU is still unpicking the implications of the Neurim decision when it comes to products. Before I hand on to Verena, there is just one more case to mention about products. But this one does not actually concern Article 1b or 3d. Instead, it's about Article 2, which states that any medicinal product protected by a patent and subject to a marketing authorization is capable of SPC protection. In this case, the German Federal Patent Court referred to the CJEU the question whether the SPC regulation applies to combinations of pharmaceuticals and medical devices. The question related to whether an SPC could be granted to Boston Scientific for a stent having paclitaxel as an integral part. In particular, the court asked the CGEU if an authorization granted for a drug-device combination pursuant to Article 1.4 of the Medical Devices Directive has to be considered equivalent to a marketing authorization according to the Medicinal Products Directive, if the drug component has been examined for quality, safety, and usefulness by a member state authority for medicinal products in a procedure comparable to that in the Medicinal Products Directive. In its ruling, the CGEU states that further to Article 2 of the SPC regulation, a prior authorization procedure under the Medical Devices Directive for a device incorporating a substance as an integral part cannot be treated in the same way as a marketing authorization procedure under the Medicinal Products Directive. This applies even if the verification procedure of the quality, safety, and usefulness of that substance is analogous with the methods specified in the Medicinal Products Directive. As a result, the paclitaxel-coated stent was not capable of SPC protection based on the CE mark. That brings us up to date on the cases about products. So let's move on to the other big SPC issue on which clarity is needed. How must the product be identified or specified by a basic patent in force under Article 3A? To discuss this, I'm going to hand over to Verena in Munich.
Thank you, Judith. Although it is now a well-known authority to understand how the issue of identification of the product by the basic patent under Article 3A has developed, it is necessary to recap very briefly on the Mediva case. The facts of the case can be seen on the slide. Prior to Mediva, different approaches were taken to Article 3A by the national courts. Most notably, German and Dutch courts adopted an infringement test which asked whether the product in issue would in theory infringe the basic patent. If so, Article 3A would be satisfied. The courts of France and the UK, on the other hand, adopted narrower subject matter tests in which it is asked whether the product is part of the new and inventive subject matter of the patent. In Mediva, the CJEU ruled in favor of the subject matter approach. Importantly, the court said that component active ingredients are protected by a basic patent in force if they are specified in the wording of the claims. Shortly after the Mediva ruling, the decision University of Queensland, which concerned SPCs on products obtained from a patented process, followed the reasoning in Mediva. However, in Queensland, the word used by the CJEU to describe how the subject matter of the basic patent must be disclosed was identified rather than specified, although these terms have been taken to share the same meaning. Ever since Mediva, there has been a series of references to the CJEU trying to pin down exactly how a product for which SPC protection is sought is identified or specified in the basic patent in force. In particular, must the active ingredient of a combination vaccine be identified explicitly and individually, or is it sufficient for them to be referred to generically or functionally? There are actually too many such cases to summarize all of them in this webinar, so I will instead skip on to look in detail at Eli Lilly versus Human Genome Sciences. In this case, both the patent owner HGS and Eli Lilly had developed anti-neutrophil alpha antibody products. HGS product belimumab was approved to treat systemic lupus erythematosus. Eli Lilly's product tabalumab was in clinical trials but had not yet been approved. When approved, HGS would have the opportunity to apply for an SPC for Eli Lilly's tabalumab based on its own patent, but relying on Eli Lilly's marketing authorization. To avoid this, Eli Lilly sought a declaration that any such SPC would be invalid because tabalumab was not expressly named in the relevant HGS patent. Instead, Eli Lilly argued the patent is drafted only in functional terms to claim any antibody to neutrokin alpha, and this does not identify or specify tabalumab for the purpose of Article 3A and the Medeva ruling. In this ruling, the CJU explained that protected by a basic patent in force under Article 3A of the SPC regulation does not require a product to be identified by a structural formula, in this context the amino acid sequence of the antibody, but that the functional definition may be acceptable if, once construed, the claims relate implicitly but necessarily and specifically to the active ingredient in question. The CJEU then placed the onus back on the National Court to construe the claims and answer this test. However, whilst the English Patents Court held that tabalumab was protected by the patent within the meaning of Article 3A, the legacy of the CJEU ruling was considerable confusion about the meaning of its test, and a number of national courts subsequently applied it very differently. In fact, differing national approaches to Article 3A and the CJEU ruling in Eli Lilly came to a head in 3 further references to the CJEU. One from the English Patents Court concerning a combination claim and the drug Truvada, one from the German Federal Patent Court concerning a functional definition claim and the drug sitagliptin, and third, a case concerning a Markish formula and the drug darunavir, which was referred by the English Court of Appeal. First, Truvada. The Truvada case concerns an SPC held by the defendant Gilead Sciences Inc. The SPC covers Gilead's HIV treatment Truvada, consisting of a combination of tenofovir disoproxil fumarate and ampicillin in a fixed-dose tablet. The basic patent in force relied on for the SPC claims a range of compounds, including tenofovir disoproxil. Specifically, Claim 27 claims a pharmaceutical composition of a compound of tenofovir disoproxil, together with a pharmaceutically acceptable carrier and optionally other therapeutic ingredients. The basic patent does not claim or refer to ampicillin by name. In the absence of a workable set of criteria to guide its decision, the English Patents Court in its Truvada case requested a preliminary opinion from the CJEU on the following simple question. What are the criteria for deciding whether the product is protected by a basic patent in force in Article 3A of the SPC regulation? On April 25, 2018, Advocate General delivered his opinion on the question, stating that each active ingredient in that combination must be specifically, precisely, and individually identifiable in the wording of the claims of the basic patent. The use of these words appeared to advise the CJEU to take a strict approach, and it is a different test to those set out by the CJEU in Eli Lilly. However, the Advocate General's opinion did not provide guidance on how specific, precise, and individual identification was to be determined. Would it mean that compounds need to be expressly claimed, for example? In its ruling of July 25, 2018, the CJEU attempts to bring some clarity with a reformulation expanding the Eli Lilly test as shown on the slide. This approach appears to combine aspects of the Eli Lilly ruling, namely that the product must be covered necessarily and specifically, and aspects Justice Arnold raised in his referring decision, where he had suggested the product must embody the inventive advance of the basic patent. In the absence of the express inclusion of an individual active ingredient in a patent claim, the CJEU appears to intend that an ingredient is identified necessarily and specifically by the claim, if this is how it is understood, from the point of view of a person skilled in the art, on the basis of the prior art of the filing date or priority date of the basic patent, in the light of the description and drawings of that patent, and all the information disclosed by that patent. In other words, the court is emphasizing that reliance should be placed on the skilled person's understanding of what the claim means. To do so, they should use the context of the patent as a whole and its prior art and, the ruling suggests, that general knowledge. The skilled person might find a particular product necessarily and specifically covered by a claim, given the overall context, even if it is not expressly mentioned. This is a form of claim construction. However, the skilled person's interpretation of the claim according to this ruling should not be confused with the normal national approaches to claim construction. In particular, it does not appear to be intended as a scope of claim determination designed to return Article 3A to a form of infringement test again. However, the Truvada case does go some way to providing useful guidance on how to deal with the difficult issue of determining when a product is protected by a patent under Article 3A, albeit in the limited context of combination claims. In practice, however, it is to be expected that disputes will only be shifted to the question what the person skilled in the art would have taken from the basic patent, necessarily and specifically identifiable on the basis of the prior art at the filing or priority date. It also cannot be excluded that there will be another referral raising the question whether and to what extent the inventive advance criterion has to be considered under Article 3A SPC regulation. On referral back to Mr. Justice Arnold in the English Patents Court, the judge held Gilead's SPC invalid, a decision which, incidentally, is consistent with the decision the German Federal Patent Court had made before the CJEU ruling. In doing so, Justice Arnold addressed each part of the CJEU test, making the following findings. As regards the first part, the patent said nothing about the possibility that tenofovir disoproxil and emtricitabine may be combined to treat HIV. Indeed, it did not even mention emtricitabine. All the patent said is that the claimed compounds may be administered as pharmaceutical formulations with optionally other therapeutic ingredients. Accordingly, there was no basis for the skilled person to understand that the combination embodies the technical contribution of the patent. As regards the second part of the test, it was clear that emtricitabine is not specifically identifiable in the patent. It was not mentioned in the patent and was not even a member of a specific class of compounds mentioned in the patent, whether by reference to their structure or activity, as being suitable for combination with the compounds of the invention. Furthermore, although emtricitabine was known at the priority date, there was no evidence that it was known that emtricitabine was an effective agent for the treatment of HIV in humans, still less that this was common general knowledge to the person skilled in the art to whom the patent was addressed. Consequently, the judge held the SPC invalid, although it should be noted that this decision is itself now under appeal to the Court of Appeal. I said a little earlier that the German Federal Patent Court has also referred questions to the CJEU for a preliminary ruling. These concern functional definition claims in a basic patent relating to the treatment of diabetes mellitus by administration of dipeptidyl peptidase 4 inhibitors. While it discloses a number of specific DP4 inhibitors, the patent also refers to the fact that other unspecified DP4 inhibitors may be used. One such inhibitor not specified individually by the patent is sitagliptin. On the basis that it is not individually disclosed by the patent, an SPC application for sitagliptin was rejected by the German Patent and Trademark Office. On appeal, the Federal Patent Court has stated that the CJEU rulings in Mediva and Eli Lilly mean that sitagliptin is not disclosed specifically enough to form part of the subject matter of the claims of the patent. However, aware of the conflicting approaches taken in other courts, 3 questions were referred to the CJEU. The questions ask, in essence, whether a product is only protected by a basic patent in force for the purpose of Article 3A if it is provided in the claims as a specific embodiment. If so, does this mean that for a claim using a general functional definition of a class of active substances, it is not enough for the product to be individualized as a specific embodiment in the teaching of the basic patent? The CJEU has also been asked whether, depending on the answer to the just mentioned. The product is protected if it is developed using independent inventive activity after the filing date of the basic patent, but nonetheless falls within the functional definition of the claims. A ruling is awaited by the CJEU. Then there is the case concerning a marketed formula, Sandoz versus GD-Cell. In this case, the claimants challenged the validity of an SPC for darunavir, or the pharmaceutically acceptable salt ester, a product thereof. Marketed as Persista, the product is a protease inhibitor used as an antiretroviral medication to treat HIV. The basic patent in force on which the SPC relies claims a marketed formula of immense breadth. Whilst this covers darunavir generically, the compound is not specified or identified in any of the claims of the patent by name or structure or anywhere in the specification. In Justice Arnold's judgment, Eli Lilly makes it clear that it is not necessary for the active ingredient to be identified in the claim by means of a structural formula. It is sufficient for the active ingredient to be covered by a functional description, provided that the claims relate implicitly but necessarily and specifically to the active ingredient. Furthermore, it is not necessary an objection that the claim in question covers a large number of other compounds in addition to the active ingredient in question. It is sufficient for the claim to specify the product by means of a marketed formula which covers it. The Court of Appeal, however, was less certain, so it has decided to make a referral about marketed formulae to the CJEU. This asks whether a member of a class of compounds which falls within a marketed formula, or which all members embody the core inventive technical advance of the patent, can satisfy Article 3A if, upon examination of its structure, it is immediately recognized as one which falls within the marketed class, or whether the specific substituents necessary to form the active ingredient must be amongst those which the skilled person could derive, based on their common general knowledge, from a reading of the patent claims. The ruling of the CJEU in this case is also awaited, and it is hoped that it will be consistent with the Truvada ruling. And this leads to the summary of this discussion. It is clear that the national judges have found interpreting the CJEU case law a challenge. However, it could be said, cautiously at the moment, that the Truvada-Gilead case has helped clarify the area. The worry now is that there are two further referrals to the CJEU on Article 3A that await rulings. These could easily confuse the matter again if they do not properly take account of the CJEU's earlier decisions. After all, much of the problem is that past rulings in this area, and that discussed by Judith, have been inconsistent with each other. Moving on from this subject, there is another rapidly developing issue on the SPC area. This is the European Commission's plan for an SPC manufacturing waiver. Matt is going to talk about this now.
Thank you, Verena. Yes, back on the 28th of May 2018, the European Commission published its proposal to introduce an SPC manufacturing waiver for export purposes. Subject to amendment by the Council and Parliament, the proposal would see the introduction of a manufacturing exemption to the SPC regulation. The purpose of this is to allow EU-based manufacturers of generics and biosimilars to manufacture a product protected by an SPC in the territory of a member state for the exclusive purpose of exporting to non-EU markets where patent or SPC protection has expired or never existed. The Commission's stated intention is that the non-EU market access created by the waiver will create investment and job opportunities in the manufacturing of generics and biosimilars in the EU. In fact, it estimates that this would generate additional growth of at least €1 billion per year in net EU exports and would create up to 25,000 extra high-skilled jobs over 10 years. Furthermore, it anticipates the proposed waiver will contribute to a more timely onset of competition in EU markets for medicines upon expiry of SPCs. This is because manufacturing capacity established for export purposes could then be used to enter the EU market. It is important to say that the current detail of the waiver is not settled. So far, there have been a number of reports and opinions from committees of the EU Parliament examining the proposal. These have crystallised in proposed amendments in the report published by Jury on 29th January, which followed not long after a final mandate from the European Council on 16th of January 2019, setting out the Council's desired amendments. It is now for the Parliament and Council to negotiate a single text that can be passed into law. Although it's tight, the expectation is that this will happen by the end of the existing parliamentary term in April 2019. As to the substance of the waiver, the most contentious issue to be resolved is whether stockpiling of product should be permitted. The Commission proposal never intended to include a stockpiling period for the purpose of export, and nor does the Council. However, in its Jury report, Parliament has proposed an amendment seeking a 2-year period in which products may be kept before export takes place. Whether the Council will succeed in removing this remains to be seen, but it is an important point to follow. Negotiation between the Parliament and Council will also focus on a series of safeguards introduced to ensure transparency and avoid the possible diversion onto the EU market of generics and biosimilars manufactured for export purposes during the SPC term. The safeguards include, firstly, as originally set out in the Commission proposal, an obligation for businesses to provide a notification to public authorities of their intention to commence manufacturing. Such information would include the location of the premises, SPC number, authorization details for the manufacturer of the product, and an indicative list of the intended third countries to which the product will be exported. The European Council and Parliament would like this notification to extend to the SPC holder, albeit limited to basic information on the name and address of the manufacturer and relevant SPC number. They would also like notice to be given 3 months in advance of the activity relevant to the waiver instead of the current 28 days, although the actual start date of activity does not need to be given. Secondly, an obligation on the manufacturer to inform its supply chain that the products in question are for export only, and placing them on the market, import or re-import of the products to the EU might infringe an SPC. And finally, the Commission also proposes labelling requirements for the export of products outside the EU that are protected by an SPC. Parliament would like a logo to be attached to the outer packaging of the product or of the medicinal product containing it, and the Council adds, where feasible, the immediate packaging of the product. The combined effect of these measures is intended to make it easier for both the SPC holders and public authorities to detect and address infringements by existing means through the national courts, such as injunctive relief, or other control mechanisms, including market surveillance and customs control. Again, however, the details need to be settled as the legislation proceeds. Jury and the Council have also addressed the issue of whether the waiver should apply to SPC applications that are pending at the date of its entry into force. The Commission's proposal says the waiver would only apply to SPCs granted on or after a certain date following shortly after the publication of the amending regulation. However, this would cause fragmentation across member states, because grant dates will vary in different national patent offices. The Council instead proposes that those SPCs that entered into effect before the date of entry into force of the amending regulation that introduces the waiver will not be affected by it. There are then 2 categories of SPC to which the waiver would apply. Firstly, those SPCs applied for after the entry into force of the amending regulation, and secondly, as from the 1st of July 2022, those SPCs applied for before the amending regulation comes into force and which enter into effect on or after that date. Parliament has made a similar proposal in which the waiver applies to SPCs whose basic patent expired on or after 2021. In both of these proposals, the intention is that the date will be consistent for all member states and that SPC owners will have sufficient time to prepare for the application of the waiver to their SPCs. That is the current state of the proposed manufacturing waiver. But I can't finish this subject without, of course, mentioning Brexit. In particular, will the waiver come into effect in the UK? The simple answer, as a lot of things are with Brexit, is that it depends on whether the UK agrees to the draft withdrawal agreement or not. If not, and subject to delays in the Brexit date, the amendments will not be effective in the UK because they will come into force after the 29th of March 2019. And in this case, the UK would need to implement its own domestic version of the waiver. On the other hand, if there is agreement to the withdrawal agreement, the amended SPC regulation that provides the waiver will also take effect into the UK. In conclusion, it is fair to say that opinion is divided about the manufacturing waiver, and in particular the possibility of a stockpiling period. However, what most can probably agree on is that it is a shame that the Commission has not taken the opportunity to address in amending legislation the questions that have given rise to inconsistent decisions of the kind that Judith and Verena have described. So we cannot expect at the time being the certainty on whether SPCs are to be restricted to small molecule drugs or wider classes of medicinal product that further amendments to the regulation might make possible. It's not clear whether the Commission intends to address these issues any time soon. In particular, we need a simple and predictable SPC system that can be implemented by national patent offices in a uniform manner. Arnold J. expressed this as the need for bright line rules in future cases. Truvada has perhaps made some progress in this direction, but will sitagliptin and darunavir muddy the waters again? And what about the CJU Abraxas decision? Past experience suggests that this cannot, unfortunately, be ruled out. In any case, we at Taylor Wessing will keep you informed. We would urge you to visit our Life Sciences microsite Synapse, where we will be posting this webinar and where further developments on SPCs will also be discussed. For now, it remains for me to thank you for joining us and to my co-speakers Judith Krens and Verena Bertram, and to remind you please to fill in our survey which will appear on your screens in a few moments.